Good morning, everyone. I hope you can hear me. Hi.
Morning, sir. Yes po, sir.
Yeah, thank you for confirming. So this morning we're gonna talk about I think the last topic for the patent series, no, because this is part of the syllabus. So I needed to take this up, no? So patent search and its role, no, why we need to do patent search. So for everybody, yeah, so hopefully this will be not be the last class now because I still have some things that I want to discuss with you. And so we'll just wait for the others to come in and then I'll talk about the schedule that we have. But for the meantime, uh, I would like to talk about the relevance now of the patent search. We talk about intellectual property patent search. I mean the different forms of IP. And so why do we need to conduct patent search, especially when we develop products, start our business, and I think the YouTube video that you've seen earlier talks about the relationship between intellectual property and the startups. So I guess I hope that you have a better parang perspective, no, in terms of the role of IP in every business. No? So this one, right now, that what I'm gonna discuss with you is part of the series, no, related to IP. And siguro before this slide, I just want to share the one I discussed in the webinar with Chad, no, because that's where the one I mentioned to you about um, the value of intellectual property in businesses. So for every business, so especially big businesses, there is a really important aspect now for IP. So I just want to share this first. So I gave this talk to the Chad Caraga, the different from the different universities in Caraga. So um, innovation. No? So we've covered this basically. We talk about inventions, innovations before. I'll try to skip this one and give you some insights about, again, related to business now, because startups, the creation of startups, we apply IP in business now. So innovation and IP in business. So with this slide, we're gonna talk about. Of course, I introduced the IP for our participants now. So I'll pay particular attention to Jollibee. No, I think this is the part where, okay, sige, nakamute na si Marlo. Okay, I'll mute. So this part here says about what kind of IP does the Jollibee owns. No? So we talk about the different forms of IP, and it's good to look at a case, no, a specific business case, because Jollibee own different kinds of intellectual property, and that includes trademark, secret. They have industrial design, utility model, and even the domain name. No? So these are the different kinds of IP. So if you look at the trademark database that I've shown you in the last discussion, you can see the different parts or the different kinds of trademark that they have applied. And of course, the formulation of the recipe is a trade secret. Industrial design in terms of the design, no, of their packaging. And then they also have their own utility model. So this one is a good example of why you need to really be consider about IP. No? So we always provide talk to the MSMEs, members of the small, medium enterprise, no? So micro, because we want them to also acknowledge the significance of their intellectual property. No? So mga MSMEs. So when we are a startup, of course, if we have limited capitalization, so we begin our journey as an MSME. No? So we start there. And so it's worth to actually talk about the value. No? So Jollibee, this is a financial statement of Jollibee that I got now in the stock exchange. So if you look at it, you'll see that the value of trademarks, goodwill, and other intangible assets Then there's notes 14, kaning naka-highlight, no? So the value is around 50 billion. That is in billion, no? 50 billion, because if you look at the amount in thousands, naka-indicate man din, no? Amounts in thousands pesos, right? So that means that if you look at the consolidated statements, or the financial statements of Jollibee, so it's big, no? 50 billion. And the total, actually, total non-current assets and their current assets. So if you total this, is about 204 billion pesos. So nga nakadako ang Jollibee na business, no? So if you look at the trademarks, goodwill, and other intangible assets, 50 billion pesos is around close to 25%, no, of the total assets of Jollibee. No? So that's big. Trademark, it doesn't even like, di ba, we discuss about trademark, wala na siya, dili na siya ko ano, dili na siya building, dili na mo makita ba, no? You cannot get hold of that. Like, dili na siya sakyanan, no? So that's simply the intellectual property that is actually part of the intangible assets of the corporation, no? So Jollibee, that's big, 35%. So of course, we know that because Jollibee has their own significant trademark system, they have this IP, and they have a very good business because they develop very good food. No? So um, they have created a menu that, like, if you go to different places like in US, United Kingdom, Hong Kong, so they have different sets of menu. They can adapt to the local settings. So they really have a very good business now. And then Jollibee is getting popular, in around the world, especially in the US market, even in the United Kingdom, although it's small, no. That's a very big, they have plenty of Jollibees there. Of course, in the US and Canada, the market is the Jollibee penetrated the market. So, of course, that's just one of the case study, no. I hope that we should always remember that even if you graduate from the university, you become engineers in the future, and if you'll be working in a company or starting your business, intellectual property, hopefully you will consider that. Remember that, okay, this intellectual property never changes a lot, no? So it's not like a technology that over time there are different sets of rules for trademark, for copyright, no? So delay, no? So the learnings you get from this class, you can retain this for the rest of your life, no? So of course there will be updates, and but then the principles, basic principles, are already in place. Okay. Now we go to the patent search. No? So why do we need to have patent search? So what is even patent search? So basically, these are the 4 topics that I would like to share this morning. No? So patent information, conduct patent search. Why do we need to do it? What are the objectives and the types of patent search? This is a bit lengthy, no? I think designed for 3 hours, and I'll try to be I'll try to summarize if I can, no? So that it will fit our discussion this morning. So the references comes from, of course, WIPO, the World Intellectual Property Organization. We also get materials from the U.S. Patent and Trademark Office, the Intellectual Property Office of the Philippines as well. Okay. So when we look at, when we look at different countries, they have different sets of processes or rules when they get the patent application or IP application. So every country has its different sets of process, no? But the basic principles in terms of what is a copyright, what is a patent, what is a trademark, industrial design, they are all the same, no? So except for the process of how they approve the application, no? So receive and then approve. And so I would like to share is the common thing that we do, no, when there is a patent application. How is this being processed by Intellectual Property Office of the Philippines? And then when you apply for a patent, of course, basically that starts with filing an application. So containing information on the patent specification, which is submitted to the receiving office, which is the intellectual property or the IPO field. No? So for this particular discussion that we have, we may be like focusing on the patent. And I think during our discussion with patent, it is not only that engineers can own patent. No? So there are we mentioned earlier that, or in the last previous discussions that we have, that there are different types of patents. Now, if you go to the USPTO, so the different patents are like the invention patent. So remember this, the different types of patent. There is an invention patent, which is our focus in this particular case. But then there is also the industrial or the design patent. Okay. Then there is also the utility patent, and that what was discussed on in the previous, no? And there are the differences. So sa to kanang design patent, that is industrial design. Ang utility patent, that is utility model, no? So we need to remember that. But in US Patent Trademark Office, you get patent, no? When you say, oh, do you have a patent? And then if it's related to design, then you can say that is a design patent. So in the Philippines, we make use of the term industrial design. But basically, that is a patent as well. Okay. The application document that we submit to the Intellectual Property Office of the Philippines contains all the information regarding the patent that we are seeking for. No? So seeking for example, if you have an invention patent, so it contains, no, the documents related to the invention patent. So for example, here on the right side, that is a screenshot, medyo dili kay klaro, but these are the basic features, no? Provides details of the invention, information on how the reader could carry out the invention. This is the beauty about the patent documents. If you look at, or if you conduct patent search and look into the patent databases, basically you will be able to like comprehend it, like for you guys will be able to really like copy it, no, and then produce it the same way, no? So or assemble it in your own way, no? So pwede gid siya, no? That's why there are drawings, there are descriptions, how one element is connected to another element in the invention, no? If you're like carrying out machines, no, for example. So it describes the invention claim, in essence identifying the legal scope of the patent right. Okay, so every patent application, there is a portion in the patent application that states, you know, the claims of the invention. That claims of the invention, basically that refers to, if you are the inventor, that refers to the invention that you are trying to claim because nobody else has created it before. So remember the three patentability requirements, no, to get a patent. What do you need to get? The invention must have a technical solution to a problem. And what are the other three requirements? Sorry. What are the other three requirements to get, or for you guys, your invention to get a patent? What are the other three requirements aside from a technical solution to a problem? Do you still remember it o wala na? Wala na? Sorry. What are the three requirements? Ha? Hello? Kalimot na? So, okay, wa mo gud ta nag-quiz tayo, no? Siguro sa final exam na. So the three elements, you need to pass the novelty requirement. That's number one, or newness. Now, number two, you need to be able to like, sorry, inventive, no? Dapat na inventive aspect ang invention. The third is to provide an industrial application. Please, excuse me, marag iubog ito. All right. Sorry. So we need to be able to ano no? We need to be able to like define what is our claim, what is really our invention. Okay. Next, the patent document also shows who is the inventor and the patent owner. No? So we'll give more examples later on. And provides also other legal information. No? So this is actually a legal document. No? So kanang patent document di ay class, that is really a legal document. And you can use this when you go to the court of law. So you will be able to use this. No? So as like for example, there will be a competing personality who copied your invention, for example. So you can use this reference, this patent document, to show it to the court or to the judge that you have an invention and the other guy is trying to copy it, and then actually you can ask the judge, no? In the case the other party should stop producing, selling the same invention because you have a patent, no? You have a patent, and then you can show this patent document. Okay. So the document also provides references to other patents or documents if they are relevant to the invention. Okay. So just like in your thesis or your technical write-ups, usually you do have references, di ba? So just like in patent application, it must have a prior art or ganang reference, no? Tawag na to na prior art kay na may mga previous na mga inventions that might be close or related to your invention. So the patent document provides the bibliographic information. So included here, what is the title of the invention, the date of filing, kano sa gi-file, asa gi-file, no? So the priority date, kano sa na siya gi-file, o kano sa na siya nauna, no? So that is very important because in patent application, di ba, remember in our discussion, there's a first to file rule, no? So even kung ikaw nakaunag invento and then other people saw your invention, they try to apply for patent about it, then kung sila una naka-file, then malgansi ka, no? So you will not be able to get patent later on because somebody else filed a patent that is similar or actually the technology that you have, no? So that's why it's very important to first to apply, no, your invention in the patent office. Okay. Next, also other relevant details that you can find. So bibliographic information. This is just an example, no? So this is a document, front page bibliographic information document. Title of invention is Birberella, and you will identify or see that the inventors include Mason, Platt, and Andrew, no? So you can find it there. And then it was filed on October 19, 2001. So this invention basically already lapsed, no? Because 20 years is already over, no? And then date of patent issuance, 2003. Remember that the patent has only 20 years no protection. And if this is a patent, an invention patent, then basically this has already expired, no? So that means that anybody now can actually produce the same invention, no? So what is the date of patent, and then what is the patent number, and then there is also the classification where this invention belongs in terms of the classification that was designed by the different patent offices. So there is a code. Okay. The patent document also contains an abstract and a representative drawing of the invention. So you'll see here, you have this Birella. So basically, the application is related to the Birella, no? So this is already lapsed. So if gusto ka nga, interested ko aning kuanda, yung question na lang is, kung ikaw mag-mass produce ani, mahalin ba ka ni sa market, no? Kaya naman sa patent. But then, the patent already lapsed. So pwede na nimo kopyahon. Basically, pwede na nimo kopyahon today, no? Ang question na lang is, nabay mo palit ani o imuha ni siyang negosyohon. Okay? So we're talking about business, no? So if the people own, for example, ang kanang mga inventor ani ang owner sa patent, ilan ang ginegosyo, no? Ginegosyo nila. So that's why they sought for patent because sila mismo, they don't want others to copy their invention. So I don't know kung kaning invention na ano ba sale, no? So kinala ba ang sale ano, no? So sulat na sale ang pinaka-importante, naabay halin, no? Importante gining naabay halin. Okay? So that's very important. Okay. So, di ba kung tao naman ni siya, this is a design pattern, basically you can copy this, di ba, because of the drawing. Okay? So, napag-i-abstract, then you can provide insight. No, even in the drawing itself, murag dali naman kaayo dayon kopyahon. So, yeah, if there a question, dili pwede mag-apply. Yes, Jobel, good question. Dili pwede mag-reapply og patent. No? So, dili na siya pwede mag-extension. So, 20 years is enough. So 20 years ago that was invented. Ang question sa ato ron kay is that kind of product still relevant today? My answer would be yes. I think my question lang yun is this gonna be like, what is your market for this particular product? Maybe kana mga resort, no? Sa Boracay, yung mga resort, basig ganahan sila, no? Interesado sila. So meaning to say, you have this specific market where to sell that kind of product. So, Jubel, I'm sorry that will not be extended anymore. But there are particular cases, no, mga exemption in terms of when can be a patent be extended. Now, in the US, dili sa Pilipinas class, no, I haven't read a case na related sa Pilipinas that the invention patent was extended. But in the US, the medicines related to medicines, no? So related to medicines, the pharmaceutical companies would seek for extension, no? So usually makita na mo, nakoy nabasa nga document sa una, 5 years extension, no? Because ang problema gud sa medicine class, like for example mga injection, di ba? Mga injectables ng mga medicines, dugay kaayo ang patent application process, no, approval, no? So sometimes the US Patent Office would like approve the patent mga around 15 years. So that's the only time that, like for example, these pharmaceutical companies would be able to really capitalize on their invention. So that in the US, so pwede siya hindi siya na ma-extend. Very specific case po. Very limited case. All right. So, okay, patent specification. Wait, where is my not moving? Right. So, other thing is that there is this substantive part, no, aspect of the invention, because the patent documents sometimes there are short patent documents. There are also very long patent documents. Yeah, mga around the most that I saw, around 500 pages. Grabe, no? 500 pages. Nga nakataas ay ilang patent document. All right. So a specification of the invention includes background invention. So this one you can see this document. No? You can see this in the document, patent document. Okay. So summary, brief description. So basically, if you read the document, you will be able to comprehend really the invention. What is the invention all about? So sa claims naman, as we go back to our discussion in patent, so the claims part of the patent document defines the scope of the legal protection. Kumonto na sa korte, that is the only part wherein the judge, the lawyers of other parties will dispute. No? So, lawyer A, lawyer B, for example, ikaw ang inventor, so you have your own lawyer, and then you kind of, before actually we go to court, there is like potential ba nga isettle siya outside of the court, no? Because once the trial begins, that's very expensive, no, for people to do that, no? Even in the Philippines. So there is like some kind of sige mag-settlement sa tao, kung dili ma-settle mo na time nga mo to gyud korte. So the claims part of the patent document is the only part nga maoro na ilalisan dito sa korte. Mao gina sa ilalisan. Kay mao man nag-define nga unsa gid ang invention, no, tinuod. So na ba kay right, no, about invention. I will not discuss this because this is related to patent drafting, no, kaning drafting claims. Yeah, so I think I'm repeating myself here. So in patent litigation, interpreting the claims aspect of the patent document is the first step in determining whether the patent is valid and whether the patent has been infringed. So it is the obligation now of the lawyers of the inventor, especially that, to prove to the court that the invention has been infringed. So basically that's a difficult thing to do. So in the patent document, so you see here we claim or I claim or simply claim, no? So the document you'll see that. Basically, the statements here are the claims of the invention, no? Kani. That is claim number 1. Mo na ginatawag na to nga claim number 1. So imo na siyang i-discuss, no? So gina-discuss na sa mga patent drafter ilan na i-discuss. Okay? So this is related to beer barrella, di ba? So I mentioned a combined beverage container and shading apparatus comprising beverage container for containing a beverage. So meaning to say, ang invention di I-class, it's not only the umbrella but including the beverage container. So if shown in the figure earlier, di ba? No. So if you follow and read this, so basically you'll get the idea of the invention. But for now, this is not our focus, no? So it's about the entire process of conducting a patent search. Okay? Okay, nabalik niya siya. So basically, class, if you look at the development today and in the past, so conducting patent search before, conducting or trying to find for information about the patent. So manually, it's being done. No? So page by page. So imagine yourself going through a library, and then the library will have different drawers, cabinets, and then you'll go there and then try to scan it. So mangyari gid no? So sometimes mo man yung ginatawag nato no, ang patent databases are actually a patent library. So they are arranged in terms of category, related to agriculture, related to food. So they're also arranged, no? So really physical search, no? If you are concerned about documents existing in other countries, so they have to travel to a specific location so that they can find that document. I think I mentioned this before, class. That Albert Einstein, our very own course, very popular Albert Einstein. So I would always claim this. Ang atong lolo, Albert Einstein, he was once a patent examiner or patent clerk in the Switzerland Patent Office or the Swiss Patent Office. I'm sorry for that. I have a cough and then I can have having a sore throat. No? All right, so see, Albert Einstein was once worked in the Swiss Patent Office, no, and then actually I think the theories, the mathematical theories was developed when he was in the Swiss Patent Office. No? So, medyo trivia ni siya. So, yeah. So, that means the innovation, the invention part, bragra gid niya na kuan, no? Because namagod sa Patent Office. Okay. I think there's a documentary about him in YouTube. I think also in Netflix. Okay. Right. So of course today we don't have to go to places, no. So what we can do is conduct patent information search in the different online databases. Now, of course, there are different online databases that you can find. That includes, of course, the WIPO and then the ESPASnet. ESPASnet is the patent database of the European Patent Office, or the EPO. That's why the domain name here is www.epo.org. No? And then also IPOFIL, and then USPTO, and then gpo.go.jp. No? So you can basically go to these databases. No? For me, I always go to WIPO or ESPASnet and IPOFIL. Kana lang, because the documents established or published by the US Patent Office are also published in EPO, no, and also in WIPO, no. So pwede ka one-stop shop siya. And then WIPO, for example. So let's try to open a website, no, para makita ninyo. So i-share screen ako. Okay. Kita. Hindi na ko makita. Dreno. So I'll just no. Here na lang. Oops. WIPO patent scope. So pwede nyo i-search gapon sa Google, no? And so here, that is the website. So WIPO or patentscope.wipo.int. So pwede nyo i-search sa Google first and then ano. Now, it says here, using PatentScope, you can reach 100 million patent patent documents. Last time, early this year, when we had a patent search webinar, no, for the agricultural AB students. So this was only like around 98 million documents. And then I think they have added 2 million. So na mo na siya 100 million. Amazing. So you can find documents every here. So when we talk about the Barella, because that was our example, no, in the patent search document. So I'm using only the simple search. Beer Barella man siguro, no? It's not Beer Barella. Beer Barella. Ano ba to? Yeah. So simply as that, no? Very easy, no? So you just open the patent scope and you find here the beer barella we're looking for, no? The beer umbrella. No? So beer umbrella. Okay. So the present invention provides, so meaning to say you can really read and go through, no, and determine what is the state, no, of this. Okay. So there will be description. That is the I don't know. This is the bibliographic page that we mentioned earlier. And then if you go to the description, then you can read the description, the background of invention, the summary of the invention, the brief description of the drawings, the detailed description of the invention, what is it all about. So the patent document in itself is not that very long. No? So usually when we write patent documents, so kani man sila gid ang kanang kinahanglan nimo i-detail, no, kaning description. Then the inventors, what did the inventors claim? No? So that's why this is the same as what I've shown you in let you see in the PowerPoint file. No? So there are only 10 claims. Of course, the claims So that's why there are patent agents, no, that we call to draft the patent document. So there is a claim number 1, claim number 2. So yeah, they are all even very specific in terms of the size. No? So umbrella is 5 to 7 inch in diameter. No? So basically what you can do is like just follow this. No? And then you can supposedly recreate this. That's the beauty about patent, no? Because you can supposedly recreate it. So other than this, yeah, so there is a different form as well, no? Yan isa. So that is the invention. Okay. So usually sa description, you can read what is the problem. So if you go through this, okay. So what you can do, class, is use the patent scope, and then you find technologies that are similar to this. No? Okay, going back to the slides, because we talk about the databases now. So other than that, the databases, what you can do is also find updates of about new invention in the different journals, also magazines, even in Google. So Google. I don't really like Google that much in terms of like for example, if you want for the sake lang of demonstrating it. So if you want to go to the site is patents.google.com. For me, I don't really like it because sometimes very complicated ang search string nila, no? So kanila ang Birberella because it's easy to find. Dali lang dayon siya, no? Dali lang siya dayon makitaan. But if you're looking for example, machine related to cacao, for example, no? So that means that sometimes there's so many. The result is about 210,000, and it's a bit difficult to find it, no? Kung daghan kaayo. So this is a machine. No? So look at the drawings, no? Machine, a multi-system beverage machine. So pwede siya coffee, pwede po siya cacao, no? So if you look at this class, if you're an electronics engineer, mechanical engineer, or even any other kind of engineer, if you follow closely the descriptions of the inventions, you can actually recreate it. No? So that's the beauty about the patent. So even siguro mga man mo geology man, no? So di ko familiar geology, pero even mga sabon-sabon lang, no? So kanang mga sabon, sudlanan sa sabon, any kind of stuff daghan kay ka makita ng mga related to inventions related to sabon. Okay? That's the beauty about doing patent search, no? So you'll get documents na you've never read them before, things like that. Okay? So I think you still have time, no? Any questions so far? Class? Do you have questions? Any questions so far? Hopefully you're still there, no? So, all right. The value of patent information. So technology transfer and foreign direct investment, avoiding duplication. This is the most important thing that we always like. Yeah, thank you for confirming, Jubil and Jessa. Yeah, the value of patent information. So sometimes in the R&D, especially in the university, we discourage really kanang mag-duplicate of invention, no? That's why gina-request gina mga estudyante, labi na mga ECE ageng nga paghimog yung pag-conduct mo patent search, no, for us to know if that machine is not existing yet. If it's existing, the beauty is also that you can further innovate or improve the technology. So unsa man day missing aning existing technology that is available in the patent database, no? So that's the most important thing if they're existing already. Okay, because doing it time and again, that means that balik-balik naman eh, no? So it's no longer new, it's no longer novel. It's about avoiding the duplication of the R&D work. So the patent document can also serve as like generation of new ideas, no, new technical solutions from the existing solutions that is already available as the state of the art in the patent databases. Okay, so it means that really it's avoiding duplication and developing new technologies that did not exist yet. Yeah. Sometimes kanang mga products without class, kanang mga products sa mga companies, usually they sell it to the market pag naana sila patent grant, no? Nga na ilang style, ang uban. So meaning to say, you can actually determine the technology in the patent databases before they are released in the market, no? So siguro what we can do is that, for example, we go back to the patent search, no? So for example, if you're very interested, so let's go back to the patent scope because that's what I am very confident na in terms of. So for example, if we look at Apple, so I'll do the search na field combination because this is where like the applicant can be provided, no? Application number or applicant name. For example, Apple, if you're interested to determine what is the latest technology that Apple is generating, immediately you can find how many documents Apple has. In the bottom, you'll see 56,000 results. So there are 56,000 documents related to Apple Incorporated. See? So in these documents, imo nang isa-isa kung gusto lang what is really Apple is doing, no? So these are related to electronics. So they have these touch sensitive displays, date of patent application. So you can really follow what is ongoing in terms of the technology development in Apple. So there's also machine translation, especially for the Chinese na application. So you can search and find the documents here, and then you can play around. Of course, you guys are really good at in terms of using the internet. No? So what if application date, for example, no? So you can actually try to process it. So mo ni ang pinaka last, no? So it's also Apple Incorporated as I think September 12 or December 9, 2021. This is the latest patent application of Apple. Devices, methods, and graphical user interfaces for messaging. Sa din siya, so you can like explore, no? So what's the latest in terms of technology development in that particular company, for example. Okay. So that's the beauty about conducting patent search. That's all. Okay. And so, yeah, these are different reasons why we conduct the objective. So there are different reasons. For companies, really, this is very important. If you're a businessman, you don't want to develop a technology that has been created already. For example, if I am a company, Apple company, I don't want to develop technology that Samsung has already generated because Samsung will, I don't know, raise or parang file a lawsuit against me because I copied their technology or their invention. So that's very important for every businesses. So that means that you need to think, or that's where the designers, the innovators in Apple, or in both ways, no, either Samsung or Apple, they kind of develop their technology, and avoid what is already being offered by the other companies. So it's not just about Samsung and Apple, even Huawei. So they are very careful in terms of patent infringement. Okay. Okay. Ang case study sa patent information, for example, mention about territoriality. So ang patent you need to apply that to specific locations or territories. Now, for example, if there is a patent or application in the US but was not filed in India, that means to say that basically you can study the patent document in the US, the drugs that was developed by Pfizer, and then mass produce it. For example, no, there was a patent in the US by Pfizer, and then it was not applied for patent in India. That means today that to say that the pharmaceutical companies of India can study the medicine, the product of Pfizer, and go around and study carefully and then reproduce it. Although it's not easy to reproduce it because of chemical formulation, things like that. But these have been the practice of India, and that's why they have been able to develop cheaper medicines for their countries. Even China get plenty of medicines in India, no? So they make use of the patent information to reproduce the same product that were not protected in their territory. Okay, I hope that you'll be reminded of that. No? So that's the essence of why. Okay. It's the same or true with Unilab. No? So basically, I had uh, well, because credit to my wife, no, because she is into the medical field, so she was able to let me parang know the people in Unilab, especially their vice president. Actually, president na siya karon. Si Attorney Ochave is very, very familiar with intellectual property. And he says that it is one of the reasons why Unilab has grown to be a multi-billion peso company. They are the biggest pharmaceutical companies in the Philippines. And the major reason is that they've been able to copy. No? So even the Attorney Ochave said they tried to copy the available product from other companies in Europe, etc. Because they're not a research-based company. No, ang research-based company are Pfizer, and Sanofi. Mga dagko ng pharmaceutical companies, they are the research. So they lead the research. You've seen that even in the AstraZeneca, no? You've seen that in the development of the vaccines, di ba? So these are the popular brands, no? So Astra, Pfizer, even Moderna, these are the guys that do R&D. But Unilab is not, no? So what they're doing is that they try to look at the medicines. Of course, ang labad sa ulo, how you treat headache before is not different from treating the headache today, no? So that means that there are for example, the generic is paracetamol. Then they develop biogesic. They actually uncover this in other I don't know, in other products from other foreign pharmaceutical companies. So they are the biggest pharmaceutical company. I just want to share this because we invited them during the 2018 SciTech with them. No? So I asked Attorney Ochabi to come down here in Butuan to give a talk about how Unilab actually kind of parang ano, no? So they were able to maximize the benefit of the patent information. No? So he discussed about this in one of our forum. No? So this was taken actually in courtesy of Professor Jao Vergara. This photo was taken when we were trying to enter the Almont Inland. No? So I mean, Almont Inland ba ni or dito sa kanang sa Libertad. I mean sa Libertad. So he was our speaker, and so he really discussed about the use of the patent information when they tried to establish Unilab. And then it's big. So they became big. All right. So now I hope you, I don't know, parang, para bang ano ba, you're able to like appreciate how really important intellectual property is in businesses. No? So, managingon nila nga, if you have IP, you have really an advantage, no, distinct advantage over your competitors basta na kay IP. So please hold, I just have to attend this call. Please hold. Right. Going back, these are the different kinds of pattern search, but I'll try to cover the what is the most important types of search here now because we don't have much time. Um, yeah, hopefully we can cover this in the last 30 minutes. So these are the different kinds of search: pre-application search, state-of-the-art search, novelty search, patentability and validity search, name search, technology activity search, infringement search, and legal status search. Somehow, some of these things were already covered now, but I think we need to kind of do the deep dive. So for pre-application search, the patent application process is time-consuming and expensive. Therefore, the inventor should conduct a pre-application search before filing a patent application. So the invention at first is just an idea, of course. Then the tendency of many of the inventors might be to perform immediately a novelty search, not to determine if their invention is novel or not. So the best inventor could do would be to search based on a vague idea, vague picture of prior art. So in the past search, the inventor should look for any printed applications, public knowledge, or patents already issued in his country or a foreign country that may relate to the particular invention. So not as advice, no? So the past would also prepare the inventor for the next steps in the search process known as the state-of-the-art and novelty search after getting ample information on the available publications and public knowledge. Okay, so this is pre-application. Now, the state-of-the-art search, so this kind of search is also referred to as information search. State-of-the-art search are especially useful for technology development or technology transfer purposes. So information search, no? So perform to determine the general state of the art. So unsa di ihang kwan karon, no, state sa kaning specific technology. If you're looking about related to artificial intelligence, so what is the um, state of the art karon in terms of the artificial intelligence? Okay, so this is to find solutions to a given technical problem as background information for R&D activities in order to know that patent applications or publications already exist in the field of technology or research. Okay. Further reasons for undertaking this kind of search could be to wish to identify alternative technologies to solve a problem. So if you wish to evaluate a specific technology which is being offered for licensing, or which is being considered for acquisition, this type of search will give you valuable information. So meaning to say, it's simply like looking at what is the state of the art, what is the latest technology related to this, so that this can be served or basis later on in terms of developing your product. The number three type of search, often what the inventors do immediately, is to conduct the novelty search. So the objective of this search is to determine whether the idea is new. Okay. So medyo technical siya actually, it's not just something that okay immediately you can say new, no. So meaning to say you have to look at the claims, no, part of the technology. So you can say indeed your technology is new over the on comparison to the prior art. So the prior art is like very close technology or invention that is related to you that is now existing in the public or in the patent databases. So early novelty patent search can be discouraging. Basically, basic inventive ideas are hard to describe, particularly when you write it on paper. So the person who drafts a patent application wishes to describe and claim the idea in the broadest way to get maximum protection to cover further development of the idea. So when we try to work out with patent applications, we talk to the inventors. Now, sometimes the inventors would have difficulty explaining what really the invention is all about. So what we do is that we ask the inventor to, for example, draw the machine, draw the device, and then direct us from where really is the invention that is the one they've developed. Now, because sometimes the machine is big and then it's similar to others, but there is specific functionality of the machine that kind of improve the production of processing of the meat, for example. No? So there is specific technology or part there that was created that is unique, that is not yet present to any other devices, that made it possible not to perform the process needed to produce a particular product. Okay, so the outcome of the novelty search will help you with the next decision. So because this is the part where you would determine whether your invention is novel or not, if it is new or not. So depende siya, no? So if you find out during the novelty search that the invention is no longer new, that means that it's not good to apply for patent application anymore, no? Or what you need to do is how can you improve your invention such that it will be treated as novel compared to what is existing already in the market, existing in the patent databases. So this becomes difficult if during your novelty search, daghan kayo documents related, and then they are almost similar, no, to your patent or your invention that you're thinking of. So let me give you an example. No? For example, MapX. No, I've been telling you about MapX. We had this launching last time, December 1, about MapX, and then because it's a software, basically that is a copyright, no, in terms of protection. But we're trying to kind of apply also. We're thinking about looking at the potential of patent, the computer implemented invention. But then when we tried to conduct novelty search, the problem was then there are so many documents related to the invention. And so we decided that it's not practical to really apply for patent because there are so many documents. So that means to say that we did not pursue it. Anyhow, the copyright is already there. No? So again, class, for every technology, you can apply different forms of IP protection. No? Okay. That's the most important thing about novelty search. And basically, the novelty search is being carried out by, for example, the IPOFIL, no, the patent office, because they're the one who will determine also based on your application. So, submit man tag patent application, no, for example, to the IPOFIL. So when we apply for patent application, the documents will be scrutinized, will be go over thoroughly by the patent examiners. And they will also conduct the novelty search. So if to establish that there is novelty. If you pass, then you have a novelty. In order for an invention to be patentable, so this is now number 4, no? Patentability and validity search. So novelty, that's 1. So patentability, we're looking at, for example, the inventive step. No, that is the second requirement. Okay. So in order for an invention to be patentable, it is not enough that it's just new or novel. It must also satisfy another criteria known as patentability. Okay. So also means inventive step. So another further criterion for patentability is whether the invention can be produced or in uniform or commercial manner, which is industrially applicable. That is a third requirement. For this particular search, the patentability or validity search, it is made to locate patent documents relevant to the determination of these other criteria of patentability. That is the inventive step or the presence or absence of an inventive step. Okay? So when somebody, like the examiner finds it that indeed there exists an inventive step or patentability, so that means you pass the second requirement. So these are the two most crucial requirements by IPOFIL in terms of the path, the I don't know, novelty and the inventive step. If you pass that, it's easier to pass the industrial application requirement. Okay. Novelty and patentability searchers are mainly carried out by industrial property offices. Now, I mentioned to you the IPOFIL, the hospital, all of these patent offices, they will carry out the novelty and patentability searches, and they will be very, very harsh to the point that you will like sometimes doubt, no, if it's really not novel or if it's novel or not or patentable or not. No, so you have to justify why this invention that we are trying to apply for is indeed novel or patentable. So the patent agent and the patent examiner of the IPOFIL will, so of course we are the patent agent in the university, no? And then the patent examiner in IPOFIL will also do their work, and then they will try to look into the patent application, and then they will say it's not patentable, it's not novel, it's not, so you have to make justifications why it's not novel or not, or you have to revise the claims if needed to make it novel. So number 5, these are searches, name search, often used for locating information about published patent documents involving specific companies or individuals as applicants, assignees, patentees. What else? You have inventors, so you can find. Okay. What I showed you earlier about looking what are the latest technology applied for patent by Apple. So we carried out that search name. Okay. So you can go over the patent database now and go around, and then you will have a pretty good idea about what these companies are doing in terms of technology generation through the patent information they provide when they apply for patent. So technology activity search. So I'm getting ahead of myself. So these are the one I discussed basically. Apple, what they're doing, Samsung, what they're doing. For example, the Huawei, they're doing a lot of R&D in 5G. So, yeah, interestingly, I tried to look at that. For example, Huawei. For example, we go to patent scope again. Go back to patent scope. Usually, this is a simple search. So if you look at this patent scope, you can go to search and then bring that down. You have field combination. And then, for example, if you're interested to, so you can actually drop down this and then choose. Now, we are interested about the technology search or name search. So usually, who is the owner invention? That's the applicant name. So we're not going after the inventor. For example, applicant name Huawei. So because you would be interested really related to 5G, for example. Is that possible? So I'm just curious to know. So immediately the combination of Huawei and the English title related to 5G. So you'll get 83 results immediately, no? So if you go search that, that's a combination. No? So this is a patent application, applicant Huawei Technologies Company Limited. So they have this patent application, interaction between 5G and non-5G management function entities. That's one. So they have similar titles, so perhaps they are just the same patent application. So the other one is authentication mechanism for 5G technologies. Okay. Wait. So okay, I still have some battery left. So these are the titles. No? So that means that you can play around in the databases. So they have plenty. We just to page 1 pa, no? So if you go to page 2, so there are different other patent applications. System and method for customized 5th generation network. Still the applicant is Huawei, and then the inventor is identified here. Okay. So they have different inventors because these people work for Huawei. So if you're into electronics or communication field, so this is gonna be very interesting. So the different technologies that we look into were highlighted there. Okay, so Huawei. So you can also find Tesla or Elon Musk. How many inventions did Elon Musk file? So you can also do that. So this one is a bit difficult because what they're trying to do is to locate patents and publish patent applications. So it might be infringing by a given industrial activity or invention that attempts to improve on an existing patent. So usually patent agents, lawyers do this. So pag inventor, kung ikaw inventor, you don't really do this, but if in case you are interested to do, so you are specifically looking at the documents, no, that to determine if maka-infringe ba ka. Meaning to say, you cause harm to other applications. Because you will be liable legally later on, no, if you infringe. Okay. Also the same thing, legal state search. So this type of investigation is made to obtain information on the validity of a patent or a published patent application on a given date under the applicable patent legislation in one or more countries. So for example, we go back to the example of beer barrella. So ikaw, nag-mass produce ka dito sa US of beer barrella, no? And then you're not the inventor, you're not the company who made it, you invented it. But knowing that you have studied the patent database and then you saw that that the legal state, no, of that application is already expired because the 20 years have already elapsed. That means that you should be confident that you will not be even infringing, no, because the patent says the legal state of the patent document is already expired, no. So that will be your parang reason, no, why you're allowing yourself to mass produce it. So pwede gid ay class, no, for as a lesson also here, pwede gid ay nga kung naay mga expired na patent, pwede nimo siya i-mass produce kung gusto ka naapagin na siya napaihalin. No, for example, katong map, I don't know, katong rotating map nga ginabaligya sa Robinson. So there exists a patent. But I'm not even sure if the patent was applied here in the Philippines. Again, remember that the legal state or the territorial ay, no, lisoda po gayo. No, so there is a territory aspect, no, in terms of the legal para protection. No, if those guys in China, they were not able to file a patent here in the Philippines, katong rotating maps, meaning to say, you guys can actually copy the same product, mass produce it here in the Philippines, and sell it. Pwede gid siya, no, as a business, no? If they were not applied here in the Philippines, and you rebrand it, so may tawag ninyo, ana, no? For example, mangita ko kuan pangalan day, Kernel's rotating map. Di ba? Kernel's rotating map, pwede gid siya. And then produce it, mass produce it, if that will be your business. And even better if you can improve the design or technology that is even lacking, no, in that particular invention. Pwede gid siya, no? So you will not be infringing. Because in the first place, that patent that exists in the US, exists in the China, or in other economies, they did not apply for it here in the Philippines. That's why on the other or reverse also class, no, if you have a technology, you applied for patent here, and you are interested to apply to other countries, nga pwede siya mabaligya, then you have to seek for patent application in other countries as well through the PCT, through WIPO, the Patent Cooperation Treaty of the WIPO, right? Okay. So next, okay, that's it. I think napaspasan ako gamay. Yeah, 11:39. Yeah, so do you have questions, clarifications with regards to this topic that we have today? Questions or clarifications that you would like to ask? Okay. Hopefully you're still there. So let me ask na lang, no, because the final schedule, final exam now schedule is that on January 3 to 7 or January 3 to 8. Okay. So are you okay, guys, if the final exam will be on January 6? because there is a memo now that we need to submit the grades a week after. So maglisod na kung extend, no? And then there's the other one is the pitching event. So would you be able to like mark your calendars? I don't know when can you possibly be. I cannot do it on Saturday because I have also classes, my own classes in Ateneo on Saturdays. So final exam would be on January 6th. Would that be okay, guys? Or you want it early before December break?
Okay na ang January 6, sir?
You're okay with that? Okay.
For me, sir, I don't know sa
Sige. So I asked Ma'am Chris of our college secretary, no? So the schedule for the final exam would be January 3 to 6, 3 to 8 day. So ingon siya nga next week daw break na daw starting 18. And so there are two things that I wanted to do, you know, so because I promised that we will have we'll have the pitching. So the pitching event, kano sa aman ta mag-pitching event. So if the final exam would be on January 6th, so I'll give you, so if you're okay on January 10, pwede po siya the final pitching about the presentation of your business idea. Sige, I'll post this in the, because there are only 16 here. So present today in this class is Colonel Areza, Larissa Lised, Kiana Villar, Matt Salanya, Jessa, Cabreros, Jubebul, Jessel, Amil, Yani, Maiza, Grace, Keisha, Jen, Elizabeth, Lloyd, Jan, June Carl, and Marlo. So there are only 16 of you here. So there are other pa no, wala din, no? So yeah, summary, you can have the summary until, so mag-post lang ko guys, no, sa I'll post it, try to post it. I can have it until tomorrow siguro, no, tomorrow midnight, the summaries. Yeah, is that okay na tomorrow midnight or you need more time?
Sir, kung okay lang, sir, kasi pwede pa extend sa time, sir, kay nato ano karon, sir, sa GL, sir. Please, then my webinar this afternoon, sir, 4 to 6 p.m. po.
Okay. So yeah, so ang katong ko so basically what you can do is extend it to until Friday. Would that be enough?
Yes, sir, taas na kayo na time, sir. Thank you, kaayo.
Sige, kung taas na siya, para makasubmit dahil mo 15, no? So I'll put it in the na lang. Sige. I'll be giving a quiz on Thursday, by the way. No? So Thursday about IP, including this pattern search. No? So our topic. So we'll not meet on Thursday. I'll give you time, no, to go over the materials, then I'll have a quiz on Thursday. All right? So and then Friday na lang dayon ang deadline sa mga summaries. I'll put in the LMS, no? So dito na lang ninyo i-submit. Ayan na lang na i-email sa ako, no? Okay lang? So I'll give you time until Friday to put there. So basically, you guys who attended this class should have a distinct advantage in terms of expounding your answers, no? Because supposedly I will not be posting the PowerPoint slides, no? Because I'll depend on what I discuss during this, no? So if you were taking notes and things like that, if you were listening, just for me to let everybody know that might be the case, no? All right, so I'll update the LMS later tonight, and then the summaries for each of the topic that discussed, I'll put it there so you can work it. I'll give specific deadlines, and then for each of the discussions that we made, no? And then I'll give siguro 1 week for every topic. All right. And I hope that would be enough time na for you. Last Thursday, upload Jubel. That's I need to think about it, no. Pero yeah, so I can provide the materials online. So ang recording. Were you able to attend the class on Thursday, last Thursday, Jubel? Okay. So I hope ano no. Okay, sige. Sige, I'll try to post na lang, no? So that you can provide the summary. Okay. So I'll post usually I post in the YouTube, no? So dito na lang ninyo tanawa, then I ask you to provide the summary, right? Okay. Sige, I'll give the link, no, and the LMS related to what we discussed. Okay. Katong sa recording. Okay, other concerns? Si Matt, asa gali mabilong nga patent search whether or not the patent holder can claim infringement. Sorry, sir. Kato dito sa infringement search. Actually, ang infringement search, you're trying to understand, no, kung ang imong invention ba karon na kay ma-infringe nga lain, no? So kana siya. Pag ang uban nga kuan, ang uban kung mangupya sila sa imo, no? So meaning to say na kay patent document kay, so that's when the time nga kailangan ka mo raise, no, na kay legal nga kuan. So for sa infringement patent search, so dito na makitaan kung maka-infringe ba ka o dili, no? So that means to say for lawyers to determine or for patent agents to go through the patent claims, no? Sa claims. Dito mo sa claims tanawon nga pareho ba gid ni or dili, no? Kay once nga pareho ang claims ninyo, gi-claim, no, kay mo to istorya nga when you write the claims, mao na imong pinaka-importante nga mga inventions statements, no, sa related to your inventions. So what you're trying to do is that dapat when you go over the patent document, makita nimo nga dili sa pareho, no? That's why you have a different claim. So sa claims part sa patent document. All right? Okay. All right, you're welcome. So yeah, so January 7 final exam, I'll give myself time, not for you also. I don't want to give you exam immediately by January 3. No, kay murag January 1, murag bakasyon pa gina January 2. So January 3, I was thinking about mag pitching unta, pero you will not be parang kanang holiday kuan killer ng ano mag-exam dayon sa January 3. So I'll let you enjoy your New Year. So we'll have the exam on January 6 and then pitching event on January 10. I hope that's okay, no? So if that's okay, please thumbs up. If that's okay. Thumbs up na lang, everybody. Okay. All right.
Okay, good kayo, sir. Sana
All right.
unahon sa inyo subutan kayo.
Yeah, so I hope you'll enjoy your vacation para ma-maximize your vacation, especially this COVID. No, so malls are open. I think you guys have been fully vaccinated, so pwede naman maglaglag karong bakasyon. So that means to say that I will not be meeting you on next week, no? So next week I will not be meeting you. Enjoy the rest of the holiday. But I will be I hope to meet you short on Thursday, no? Thursday. All right. I'll still be meeting you. Perhaps that will be my last class, no? For the year and for the semester on Thursday. All right. So see you on Thursday. Although I'll be giving you siguro dili na lang quiz, assignment na lang that you will kind of para sa quiz, pero you can answer it parang flexibility wise, you can do that in a day's time, related to IT. All right, guys. So thank you for joining the class this morning. I hope you learned something new, different also. So see you on Thursday for our last class. Thank you, everybody. Bye-bye.
Thank you, sir. God bless.